And we can add other people to the rooms. So if you click on the jail booth up there, on the right, it says assign to, and then you just pick the room. And then. Did you unmute him first? So just move, I'll unmute him and then you can move him to room 3 or whatever. That should work. Have Brandon let him know. I'll let you know if there's no sound.
Okay, I'll just get that.
Session, the Honorable Andrew Wheeler is now presiding.
Thank you. You can be seated. All right, if you're in the courtroom this morning, you've been charged with a misdemeanor or a gross misdemeanor by the cities of Battleground, Richfield, or La Center. When I call your name, I'm going to ask you to come up to this rostrum in front of me. I'm going to ask you your name and your date of birth, and we're going to discuss how you would like to proceed. I cannot give you legal advice today. I can discuss your options, though, for the arraignment proceeding. Ms. Cox-Duran, if you'd like to come forward, please. Can I have you state your name and date of birth?
My name is Lauren Cox-Duran. My date of birth is 7579.
Ms. Cox-Duran, this is a case that's been on warrant status now for several years. That is a December 2nd, 2020 case, driving while suspended in the third degree. Driving while suspended in the third degree, ma'am, is what is called a simple misdemeanor in the state of Washington. It's subject to 90 days in jail and a $1,000 fine. We also have a trip permit violation that is also a simple misdemeanor in the state of Washington, again, subject to 90 days in jail and a $1,000 fine. I have reviewed the police reports for both cases and I have found probable cause. Because these are criminal charges, ma'am, you have several important rights, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today, ma'am, for a court-appointed attorney?
Yes, please.
Okay. I'm going to ask you some questions about your income to determine if you qualify. Do you receive any manner of state assistance at all right now?
I'm not at the moment. No,
Okay. Are you employed right now?
no, not at the moment.
Any income in your household?
No.
Okay, I will find you do qualify for an attorney. Court will assign Mary Kay Gaffney.
Okay.
So Ms. Duran, at this time, we're going to be entering a not guilty plea on your behalf. I'm going to be assigning some future court dates and to allow you to have some opportunity to speak to Ms. Gaffney. Certainly when a case is this old, the court has some concerns about you coming back to court. My hope is that if I give you future court dates, you will return.
I will.
Certainly, if you don't, I'm going to have to put a warrant out for you again, okay? First of all, we're going to assign what is called an attorney pretrial. That is a date for Ms. Gaffney to appear to discuss your case with the city attorney, Ms. Carmy. It's not a required court date for you. Your next mandatory court date is going to be on the 4th of May, 2023, and that's going to take place at 10 o'clock in the morning. That is a mandatory court date, meaning if you fail to appear, a warrant again can be issued. Your conditions of release are as follows: to violate no laws, notify the court of any change of address or phone number. You're not to drive without a valid license. I am releasing you at this time on your recognizance. Okay. Please make sure that you are staying in good touch with Ms. Gaffney. We're going to get you some paperwork over by the door then. Once you have your paperwork and you've been able to connect with Ms. Gaffney, you are free to go.
Okay.
Thank you, ma'am.
Thank you.
Yep. Sir, can I get your name?
Davis, James.
Okay, come on up, Mr. Davis. If I could have you state your name and date of birth, sir, for the record.
James Francis Davis, 3362.
Thank you, Mr. Davis. Mr. Davis, you're making a first appearance arraignment on a charge of no valid operator's license and failure to transfer title within 45 days. These charges are both simple misdemeanors, meaning they are subject to 90 days in jail and a $1,000 fine. Because these are criminal charges, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today, sir, for a court-appointed attorney?
Please.
Okay. I'm going to again ask you some questions about your income to determine if you qualify. Do you receive any manner of state assistance at all right now?
GA food stamps.
Okay, I will find you do qualify for an attorney. Court will assign Ms. Gaffney as well. So, sir, at this point, I'm just going to be assigning some future court dates and entering a not guilty plea on your behalf on both charges. I did review the associated police reports and did find probable cause for the record. The first date we're going to be assigning is a date on the 12th of April, 2023. And that's a date that Ms. Gaffney is going to be able to appear to discuss your case with the city attorney. It's not a required court date for you. Your next mandatory court date, sir, is going to be on the 4th of May, 2023. And that's going to be at 10 o'clock in the morning. If you fail to appear at that time, a warrant for your arrest could be issued. Conditions of release include violating no laws, notifying the court of any change of address or phone number, not driving without a valid license and insurance. You are being released at this time, sir, on your recognizance. Do you have any questions at all regarding the court proceeding today or the future court dates?
I'm just trying to get it through DMV, get my compliance or get my register. I have to go back to California in order to get paperwork before they register it up here. So
Yeah.
I'm in a little catch-22 right now, but
Okay.
I'm willing to comply. It's been impounded, so I won't be riding it.
Okay, sounds good. Well, we'll get you some paperwork over by the door. We'll let you connect with Ms. Gaffney this morning so you can share some contact information and we'll go from there.
Thank you.
Thank you, sir. Have a good day. Ms. Engstrom, can you hear the court?
Yes, Your Honor.
Good morning. Are you ready on Mr. Antonoff?
I am.
Okay. Mr. Antonoff, can you state your name and date of birth, please, for the record. All right, Mr. Antonoff, it looks like we're having just a little bit of issues. Sometimes when the jail booths first connect, there's an issue with audio. So let's just give this about 30 seconds and then we're going to ask you again. I promise I'm not playing a trick on you. It's just a matter of, I can see you talking. I know you can hear me. I just can't hear you. So just give us just a second. And just noting, I do have the statement of defendant on plea of guilty along with the judgment and sentence. So thank you for providing that. Mr. Antonoff, let's try again. Can I have you again just state your name? Speak up just a little bit if you can.
Konstantin Antonov, August 29, 1994.
Mr. Antonoff, I could hear you perfectly. Thank you very much, sir. Apologize for that delay.
Great.
Mr. Antonoff, by the paperwork that we have today, it looks to me like you are resolving your malicious mischief City of Richfield case. Is that your understanding?
Yeah,
Okay. Have you had plenty of time to speak to Ms. Engstrom about your case?
not plenty of time. She just spoke to me right now for like a minute, but it's enough for me.
Okay.
I
Do you need any additional time at this time, sir?
No,
Okay. If during our plea today, you would like some additional time to speak to your attorney, just get my attention. I'm more than happy to have you speak to her again, okay?
I would have been happy to speak to her like a day before court, face to face, but I didn't have that time. I spoke to her for 1 minute. I guess it's enough. It's okay.
Okay. So certainly, like I said, I'm not trying to certainly rush you into any manner of resolution that you are not comfortable with. Are you comfortable proceeding at this time?
Of course.
Okay. I have that you are Konstantin Antonov. You are 28 and you've completed the 9th grade in school. Is that correct?
Correct.
Are you able to read and understand English?
Yes, sir.
The charge which you are pleading guilty to malicious mischief in the 3rd degree domestic violence is a gross misdemeanor. it is subject to 364 days in jail and a $5,000 fine. In entering a plea today, you're giving up several important rights that I'm going to review with you and make sure you understand. You have the right to a speedy and public trial by an impartial jury in the county where the crimes alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and the witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. Do you understand those rights, sir?
Yes, sir.
And do you understand that in pleading guilty today, you are waiving or giving up those rights?
Yes, sir.
Okay. The prosecuting attorney has made a recommendation. You understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law. Do you understand that?
Yes, sir.
During the time you're on probation, the court can have you pay cost, fees, and assessments as authorized by law. And if you're not a U.S. citizen, a plea can result in immigration or deportation issues. To the charge of malicious mischief, third-degree domestic violence, taking place on March 13th in the city of Richfield, Washington, how do you plead?
Guilty.
Are you making this plea freely and voluntarily?
Yes, sir.
Has anyone made any threats or promises to get you to plead guilty?
No, sir.
The factual basis reads that on or about March 13th, 2023, in the city of Richfield, Washington, I knowingly and maliciously caused physical damage to the property of Oleg Antonov, my father, in an amount under $750. Is that correct?
Yes, sir.
Okay. I will accept the plea, find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. What's going to happen now? So this is a Mr. Busby case, if I'm thinking correctly, and Mr. Busby is not present. So I'm not going to probably get any feedback from the state. I am going to hear from Ms. Engstrom, and then Mr. Antonov, if you want to address the court, you are more than welcome to. Go ahead, Ms. Engstrom.
Your Honor, I would just ask that you follow the DA's recommendation on this. He doesn't have much of a criminal record. He's on board with not contacting his dad. I think he's ready to put this chapter behind him.
Okay. Mr. Antonov, is there anything that you would like to address the court about?
No, sir.
Okay. I will follow the recommendation of the parties. To the charge of malicious mischief, 364 days in jail with 347 days suspended. 17 days to serve as 17 days to serve as jail with credit for those 17 days. There is 5 additional days being assigned on work crew. The work crew sanction, Mr. Antonov, is something through the city of Battleground. The paperwork that you will receive over at the jail will have the contact information for the Battleground work crew chief. It's your responsibility to contact Battleground to get your work crew scheduled. It's also your responsibility to do at least 1 day of work crew every 30 days. If 30 days pass and you have not done work crew, the work crew sanction gets returned to the court. Do you understand that?
Yes, sir.
It is a $5,000 fine with all 5,000 suspended.
Oh, Your Honor, if I
Yes.
might, I believe that 5 days is a leftover from something else and the box is not checked. So let me pull up the,
I can strike it. The math is correct then if it's not included.
yeah, that's correct. This was not an extra 5 days work crew. That's my
Okay.
fault. I should have omitted that.
That's okay. I'm going to strike that from the judgment and sentence, and I've initialed next to it. So, Mr. Antonov, you have not been assigned any work crew, simply credit for the 17 days that you have served.
Great.
There is a There's a criminal conviction fee of $43, and there is a domestic violence restitution fee of $250 and a filing fee. The total costs are $443, and you can get information from the court on how to pay your fine. There is also restitution, Oleg Antonov, in an amount to be determined, and the court will monitor that for at least 180 days. Conditions of sentence: no criminal violations. To obtain an anger management level 2 class through NTSI, obtain an alcohol evaluation from a Washington certified agency and comply with recommended treatment, and a mental health evaluation from a state licensed mental health provider and comply with treatment. Police reports should be provided to both agencies. Do not go on the property or have contact with Oleg Antonov. We are going to schedule a review hearing, sir, to make sure you get the substance abuse evaluation done and the mental health evaluation completed. That is going to be a mandatory court date, sir, on the 22nd of June, 2023 at 1:30 p.m. If you fail to appear at that time, a warrant for your arrest can be issued, and this is going to be in the paperwork you're going to be given at the jail. Do you have any questions, sir, regarding the sentence that has been imposed today?
No, sir.
All righty. We will be getting your documentation to you shortly over at the jail. I wish you good luck, and we'll see you back here in June. Go ahead.
Thank you.
We need an order to terminate the pretrial no contact order.
Okay. Well, we are releasing our hold because the case resolved today. I don't have a prosecutor to draft the order that is being recommended. I understand that we have to end the pretrial no contact order. Perhaps if someone could reach out to Mr. Busby, as he is the conflict prosecutor, we could get an order to rescind the no contact. Okay, just like Ms. Travers is doing that. And there is going to be a post-conviction NCO, it looks like, at least from the JNS.
That will have to get from him. Yeah, I'm gonna stay out of it, but I do think that that's very important. Yeah, there's gonna be a post conviction and we don't do a termination, right? We need Ryan to do.
Well, let's email Mr. Busby and explain.
Stephanie can start on.
I can call him if you want. You want me to call him, Ryan?
I'll text him. And he doesn't have. Okay.
Was he going to be joining us? Was it anticipated?
That's a full conflict.
Okay. Well,
Yeah.
at this point, I have provided sentence to the NCO. Do we need Mr. Antonov to continue to be connected for the actual signature? I would assume not.
I'll just have to send all his
Okay.
paperwork to the jail.
All right. So Mr. Antonov, it might just be a slight delay for us to get paperwork to you, but that does conclude your hearing today. Thank you very much, sir, and good luck.
Thank you.
That'll probably come back to me here when the no contact order is drafted. Okay. Good morning, Mr. Campbell.
Good morning, Judge. And first, I should have thought of this making appearance virtually today, and I apologize. I haven't emailed pleadings over. Are we able to, do you want me to step away for a moment and do some pleadings and email them to court staff to print off? Or what we're going to be doing is entering not guilty pleas and setting a future date forward on Mr. Koskanemi's case, Judge. But I just didn't do the return to court.
Okay, no, we can absolutely, I have no problem drafting a return to court for Mr. Koskanemi. So.
All right, I apologize that inconvenience.
That's okay, not a problem.
Mr.
Any
Koskanemi.
pleas we would have you send over, but if it's just a return to court, I'm fine with that.
Yes, Judge. So Mr. Koskanemi makes appearance on 1, 2, 3, 4, 5 counts of driving while suspended in the third degree, and then 2 counts of DV no contact order violation over cause numbers from 2021 and 2022. And ultimately, he's re-entering not guilty pleas on all of these charges. He's waiving formal reading. He's aware of the negative consequences potentially associated with these charges, understands the charges in generalities, and would ask to set release conditions this morning, Judge.
Okay. Let me first, Mr. Koskanemi, can I have you provide your name and date of birth, please, for the record, sir?
Yes, sir. It's Aaron Joe Hoskins, 03/01/1997, Robert.
Thank you, sir. I would note, Mr. Campbell, there is one case that Mr. Koskanemi is making an arraignment on this morning. It is cause number.
761, the 2A case ending in 761.
No, it's the 3A case, 3A0276936. It's a charge of failing to stop or give or info or obey an officer and driving while suspended in the third degree. It looks like this is from perhaps the arrest on most recently on March 23rd. But it is a case that I was provided a report for yesterday. It did find probable cause for both of those charges. Do you want to go into a breakout room with Mr. Koskanemi again?
So Judge, I'm comfortable if Mr. Koskanemi is comfortable proceeding forward, entering not guilty pleas on those counts. I apologize. I did not go over those counts with him. So if we could just apprise him of the, I mean, I think you've already apprised him of the charges and the charges. I'm sorry, I'm not familiar with what if it's a simple misdemeanor for failure to obey.
Yeah, so Mr. Koskanemi, there's two charges that you are being arraigned on this morning. The first is failure to stop or give info or obey an officer. That is a simple misdemeanor subject to 90 days in jail and a $1,000 fine. There is then a charge called driving while suspended in the third degree, which is also a simple misdemeanor subject to 90 days in jail and a $1,000 fine. This is an incident taking place in Battleground on March 23rd. I did review the associated police reports. Excuse me, and I did find probable cause for both charges. I want to just make sure that we have not guilty pleas entered. I'm going to enter not guilty pleas on the other charges. I want to just make sure we've had probable cause determined on the DV cases. Yeah, it looks like probable cause has been found on cause number 2A0535237. And then just reviewing the file here quickly. Probable cause had also been found on 2A0691761. So it sounds to me, Mr. Campbell, that on all of the associated cases at this time, that Mr. Koskanemi is entering not guilty pleas on all charges. Is that correct?
Yes, Your Honor, that is correct.
Okay. I am adding just right now for the record the cause number that's been most recently filed. And noting the not guilty plea on that matter. Okay, so what's going to happen now, Mr. Koskanemi, is I'm going to hear from the city attorney, Ms. Carmi. I'm then going to hear from your attorney, Mr. Campbell, and we're going to be discussing conditions of release on all of the charges. Go ahead, Ms. Carmi.
Yes, Your Honor, just one housekeeping matter to make sure, and I might have missed this, on the cause number ending in 494, a DWS3. Was Your Honor able to review for PC? I believe this is one where district court may not have had the PC statement at the time and did not find.
That is a good point. I did review the document that was provided yesterday during case review, and I did find probable cause yesterday for the driving while suspended charge 2A0104494. So I believe we have probable cause and not guilty pleas at this time now entered on all charges.
Great, thank you. So the city's position is obviously, as the court is very aware, it's been quite difficult to get regular appearances from defendant. We do think some sort of hold needs to be in place to assure his appearance. We have cases dating back to February 13, 2021, all the way through just days ago. We note there's a felony hold still in place of a $10,000 bail for a felony case with his next appearance April 5th. There's also misdemeanor holds in aggregate of a little over $3,000. We are not asking for any holds on the DWS3 cases. However, on the DVNCO case from October 4, 2022, ending in numbers 237, we are asking for a bail of $3,000, which essentially combines the two $1,500 holds that district court imposed on the two DV cases. We would then release our hold on the DV case ending in 761. So in essence, the city is asking for a $3,000 bail to be imposed on the case ending in 237 to assure his future appearance here.
Mr. Campbell, go ahead.
So, Your Honor, initially, we're asking for a set over to April 13th, 2023's docket. I think we should set that for an 8:30 appearance because I think it's very likely, regardless Your Honor's determination on release conditions today, that Mr. Kuskanemi would still be in custody with these district court holds and felony holds. I'll defer to Your Honor. I mean, there is certainly some concern that I can see that Your Honor would have looking at the pattern of non-appearance in these cases or alleged non-appearance in these cases for the administration of justice, but there's also $13,000 worth of bail and district court matters and Superior Court matters in Clark County. So I know Mr. Kuskanemi would prefer to not have multiple bails in multiple jurisdictions, so we'll ask for supervised release on intensive supervision without bail.
Let me make sure I'm understanding, Ms. Carmi. I understand that there is a $10,000 bail on the felony charge.
Correct.
Is there an additional $3,000 bail on other district court cases?
There's a combined, it's a little difficult to read from the jail roster, but there's at least a $3,000 combined bail bond on misdemeanor holds for escape, reckless driving, and an assault for DV that seems to have a standalone $1,000 bail.
Okay. And let me understand, so at $13,000 bail, I'm trying to understand why we would impose, with the costs associated with it, $3,000 more bail.
Correct. The city's position is, Your Honor, what we've seen in other cases, especially with us pushing this out to April 13. His next felony appearance is April 5th. The city certainly doesn't have a crystal ball to determine whether he might plead out and be released on April 5th. The misdemeanor cases, because they are lower bail holds, I could see those being dropped at his next misdemeanor appearance as well. So the city's perspective is that the $3,000 would assure his appearance in our court at the next appearance.
And Your Honor, I'll just provide some information that I didn't provide to Ms. Carmi, and I'll provide it to Your Honor as well. I'm actually the felony attorney on that Clark County Superior Court case. And I do not have a fast track offer or any type of offer, and I'm out of the office next week. So I do not believe that it would be possible for Mr. Kuskanemi, and I've told him it's not going to be possible for Mr. Kuskanemi to be on a felony docket to resolve that matter if he chose to do so before our hearing on the 13th. I just logistically it will not happen, but I still defer to the court and Ms. Carmi's argument is certainly sound. I wanted to provide that bit of information for Your Honor.
Yeah, so I was initially inclined to put a nominal bail in just in case he did plead out that basically he wouldn't be transferred to prison or something of that nature without our case being dealt with. I think with that additional information, I'm inclined to not impose bail on any of our cases, as many cases as we have, simply due to the cost of the city, and I think the other protections in place and the representations of Mr. Campbell today.
Completely understandable.
Okay. So, Madam Clerks, I am not going to be imposing bail on any of Mr. Kuskanemi's cases. The two DV cases that had bail on them at $1,500 each, that bail is to be removed. So at this point, Mr. Kuskanemi is going to be assigned a future court date on April 13th, 2023 at 8:30 in the morning. That is a mandatory court date, Mr. Kuskanemi. If for some way, shape, or form you're released on all your cases, you have the expectation to be in the city of Battleground on that day to appear in court. Condition of release is to violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number. If Mr. Kuskanemi is released, he is on intensive pretrial release. At this point, there's already NCOs in place. I'm not inclined, because there hasn't been new incidents, to put new NCOs in place.
Correct.
But at this time, I think that will be the extent of the release conditions based on all the information that is before me at this time. So, Mr. Koskanemi, we're going to be seeing you back here on the 13th of April. It sounds like you also have another future court date forward with Mr. Campbell. And we will see you back then. Thank you, sir.
Thank you, Your Honor. Thank you, Brandon.
Aaron, I'm going to come in and speak with you briefly about the no contact orders and the jail phones and things of that nature if I can. So I should
Okay.
see you briefly. I just want to be sure you're not.
Mr. Busby, are you with us?
I am, Your Honor.
Okay, good morning.
Sorry about that.
That's okay.
I'm on the 10 o'clock docket and
It's not a problem. So I was just wanting to let you know, and I'm assuming that you've already received this information from Ms. Carmi, that we just need a formal no contact order as a condition of sentence on Mr. Antonoff. So hopefully you're in the process of sending that over so we can get that signed.
I am, Your Honor. I'm working on
Okay,
that right now.
Thank you, Mr. Busby. I appreciate that.
Thank you.
So do we have 5 more in custodies this morning? Is that my understanding? Madam Clerk, so if you can help me out, do we have the sense of anybody else is in a jail booth at this time?
No, we only have 2 jail booths available to us, so
Okay.
until they remove one, we.
Okay. So I think with that, I would probably go off the bench. I don't have. Are we too early to call our mitigation hearings if we have any?
I could,
Wake them up.
do you want to do an ex parte dismissal on a stay?
Sure.
This gentleman he's on docket for this afternoon for stay compliance with the dog bite case.
Okay.
He's not on the docket.
Oh, he was taken off. Okay. He communicated with the court directly and provided documentation that the dog has passed away. My office has also reached out to the victim that there's no restitution owing. All medical bills have been covered.
Okay.
The stay would have ended in June, but we are presenting to you a stay dismissal early, given all the factors, and he's been notified of
Yeah,
that.
that's fine. If you want to approach, I'll just put that on the record. Thank you. All right. So this is Joshua Curtis 2A06066054. Ms. Carmi has just put on the record the circumstances. The dog has passed away. Restitution has been completed. And I have a document in front of me that the city's motion at this time is to dismiss the case. Case will be dismissed as of today's date. Signed off.
I think that's all I have for you. That'll look.
Do we dare do our 3 driving while suspended warrants right now, or?
No, gosh.
I mean, we can hang out. I can.
Yeah. Really hoping one of them would show up first. And
Yeah, I saw-
beneficial.
Yeah, I saw there was one or two that you were willing to amend to a infraction.
Yeah. No.
Yeah.
Yeah.
All right, well, I'm gonna be in chambers until we have another person in the jail booth that's ready to go, or if somebody else for arraignment shows up. So,
One of the public defenders, but they got picked up. They can't take it too long.
okay,
She said, down.
yeah, I would say I would see that they are.
Does it show that we're still live? She's
Yeah.
in the waiting room. Thank you for, then I'll tell her, thank you for.
It doesn't appear right now that I'm a co-host. In that I can't see the waiting room. But I could be.
Yeah, you're co-host.
Co-host. All right, well. All right, well, we'll be in recess until we have some other matters ready.
Yeah, no, 60%. Yes. Disposable underwater camera for children. Especially when it develops disposable cameras still. They have to be a bigger war. They hate them, they have to have so much to develop them. Yeah.
Costco used to do that.
Yes, that's where we used to. Yeah,
I think Walmart and some Fred Lighters have.
okay.
Don't quote me on that. I know my wife went and had some film developed, so one of those two stores has it.
Okay. Tomorrow. Oh.
I just stayed on the plastic. Just like.
Oh, yeah, yeah. Oh, so it's-
Actually. And we would do some. She brought her to school.
Yeah.
Yeah, so.
Guys, I should be wearing my glasses one day. I know, I'm like, I need mine, so I'm like, shut up. What happens if he does something inappropriate? Can be on TV. Is that one? That's what I was thinking.
Ms. Landwehr,
And you got to get back to work, don't you, Hayden?
Ms. Travers, if you want to let Ms. Landwehr know that I've sent over the NCO.
Yes, I'll see if she's on. She's working remotely today, so she's not here in the office.
I've printed the no contact order to the court main printer.
You want me to go get that for you?
Thank you.
You're welcome.
Thank you. You can be seated.
Your
Mr.
Honor.
Campbell, I understand that there is a matter ready.
Yes, Your Honor, we have the Clifton Brown matter ready, and I have some, well, initially, I'm going to ask for a reconsideration of his release conditions. I'm going to provide some information to Your Honor on the basis for that. And then in the alternative, we may have to briefly take a break. Mr. Brown is going to plead guilty today, kind of over against my advice. Well, so I guess I would just ask to consider release conditions first.
Okay, I'm fine with hearing argument regarding release at this time, if you want to go ahead.
So as you may recall, Mr. Brown is a veteran, I believe it's of the Army. He has been incarcerated since last Thursday on an allegation that he violated his release conditions in an assault 40B case associated with an allegation that he struck a significant other while intoxicated by picking up a DUI in Battleground. So those are serious community safety concerns, in Your Honor. You revoked his release last week, and Mr. Brown understands that. Subsequent to that, I've had some contact and communication, and I'm gonna respectfully just note that I'm going to speak a little bit about negotiations in this case without, I'm not trying to be disrespectful to those negotiations, but I'm just trying to give some background on what we have attempted to do in this case, if that's okay. And basically, I've reached out to the Vetco team, to Matt Burge. For various reasons, it seems like Veterans Court may not be a suitable kind of resolution in this case. Mr. Brown's got very limited criminal history. We don't have a current offer in this case just because it's a week old and there's been a lot of moving parts, but the offers that we do have seem likely to, in maybe a week's time, result in serious reductions in collateral consequences for Mr. Brown. And in spite of that, I think largely because he's 58 years old, he's incarcerated, he's Black, which I'm not saying to create anything other than the reality that he's been having some hard time in there with these young kids who he can barely see, who are wanting to start fights with him and things in the jail. He's contemplating pleading guilty to these more serious charges, in spite of the fact that I have good indication to believe, and I have conveyed to him that we may be able to get these matters reduced and cut his consequences severely. And I understand why he's doing that. So I'm prepared to proceed with a change of plea for him if that's what we have to do. I'm going to ask Your Honor to allow him to be let out on intensive supervision. And if Ms. Carmi has fairly and I think reasonably asked, well, if he's going to do that, I think he should be on the BART system, which I agree with. And so if Your Honor would be willing to let him out, but only letting him out on the BART system, he has no money, he has no family, he has no mechanism of paying for that. I would ask the court to consider in this one exceptional instance, based off of his, former service to our nation, to pay for the BART system. It would be cheaper than his incarceration. I think there's a possibility if he pleads out today with the type of history that he has, that he could even be released today if Your Honor was to take into account our arguments. And so we would ask that he be released, Judge. I mean, the alternative is he's going to be pleading guilty today, which I mean could be of some benefit to the community in the sentencing conditions. are going to be set that he engage in treatment and things of that nature that necessarily can't be done on the forend. But I have tied him into VA resources. He does have an understanding of how to access those resources. His car has likely been impounded at this point. I don't have information about that, but that would be it's a real detriment to him because that was his house at the time of this instance. But he's of very limited means, and so that is our pitch. We're asking Your Honor to consider in this exceptional circumstance releasing him.
Ms. Carmi.
Yes, Your Honor, this is a case, I think everything Mr. Campbell said is entirely accurate because there are 2 DV charges. I've let Mr. Campbell know that, any offer that my office makes in a global resolution, I would need to discuss with the alleged victim. That's not something I've been able to do since last week. So I have told him that if the direction that I think my office wants to go with these cases, in order to go that direction, I do need the input of the victim. When we discussed that, I think that as Mr. Campbell already stated, his client's inclination was simply to plead guilty to the charges as charged. As a prosecutor, obviously, we have a duty to the community safety, which is why we asked for release to be revoked. We also have a duty to the defendants to make sure that they're treated fairly. The city would, if this court was inclined to require Scram or BART, the city would agree to a very short set over of this matter with intensive pretrial release and Scram or BART. The city would, this is a first DUI. And in the last 15 years, Mr. Brown's criminal history is void of any violent crimes or arrests. So we would be in support of that. Obviously, I am not sure of the conditions that would have to be met for the city to pay for that. But I do also believe it's fair to say that it is likely cheaper than another week or 2 of incarceration.
And Judge, that is another, just logistically, next week is spring break. I'm not even able to be, I guess I could impact my being out of the office, but I think even if we were to set it over to next week, Mr. Brown would likely direct me to change plea.
I think one of the considerations that was before the court was certainly the perception this was an escalating situation. When Mr. Brown first appeared in front of me, he absolutely received the benefit of the doubt during that March 9th hearing, and that I didn't impose, other than a no contact order, any pretrial release conditions, and acknowledged the fact that alcohol, it seemed, was a very large part of the circumstances that had brought Mr. Brown to that charge in the first place. I think the difficulty the court has just in the reason that Mr. Brown's release was revoked was because Mr. Brown on his own was unable to get a hold of the issues with alcohol. And Mr. Brown was, because of the no contact order, residing in a vehicle. That is me laying out the dry kindling, the dry hay, and leaving a box of matches there and just hoping that someone doesn't come and light a fire. I think that the difficulty that we have here is just the acknowledgement, even by the defense, that we have very few mechanisms to ensure Mr. Brown's compliance. I don't know how it would work in regards to the city paying for release. I agree, though, that it likely would be cheaper than Mr. Brown's incarceration. I am sorry that Mr. Brown feels that based on what is going on in the jail, that he is compelled to plead guilty simply to get out of the jail. But that said, I think that is a very real consideration. So what we're going to do is as follows. I am going to release Mr. Brown. I am going to order that Mr. Brown be placed on a BART monitor. Mr. Brown, we're only going to give you a very short time to facilitate this BART monitor. And I know that the difficulty is you may or may not even have a vehicle at this point. But that said, if we do not have assurances that you are not drinking, the only place I can put you, whether it's safe for you or not, is the jail. Because that is the only place, in my belief, without substantial monitoring, that the community is safe. And in this calculus, the community is the most important thing, not you. You made some personal choices, and they may be a result of your service to our country. They may be a result of the disease of alcoholism, but they were choices. They were absolutely positively choices. And your choices put you in this circumstance. So I'm going to take the unusual step of eliminating Mr. Brown's bail obligation, $3,500. Mr. Brown is to be placed on intensive pretrial release. Mr. Brown is going to have a BART monitor, which in my recollection is either $6 or $7 a day, that we are somehow going to figure out how the city of Battleground will pay for to watch monitoring.
So, Your Honor, I'll just ask to have a brief breakout room with him afterwards so I can explain some things about checking in with pretrial supervision, and I would like to give him my cell if court staff can put that on his release order so that he can contact me if he has difficulties in facilitating getting the BART system, and I can communicate with court staff in that regard.
So my question for you, Mr. Campbell, is do you want me to impose return conditions and dates first before you do that? Or do you want to speak to him first?
No, I would ask that this matter be set over for a very brief set over to April 13th. And Mr. Brown, do you still have Mr. Burge's phone number? Can you contact him in regards to the resources that he spoke to you about on your release? I'll let him know that you're being released today. And he may be able to get you into some temporary housing in a hotel in Portland or here locally.
Mr. Brown, your next court date is going to be on the 13th of April, 2023 at 10 o'clock in the morning. That is a mandatory court date, sir. If you fail to appear at that time, a warrant for your arrest can be issued. Your conditions of release are as follows. You are to violate no laws. You're to appear at all mandatory court dates. You're to notify the court of any change of address or phone number. I'm highlighting this condition. You are not to consume or possess any alcohol or non-prescribed drugs while your case is pending. Your quickest ticket back to the Clark County Jail for a prolonged period of time is if you drink. Do you understand?
Yes, sir.
To ensure that Mr. Brown is not drinking, and honestly, it's a real risk. We are going to be placing him on 24/7 BART monitoring. The city will pay for. There are certain people in the city, I think, that are very not happy with that. There are hopefully some people in the city that recognize your service to our country and recognize that this is the fiscally responsible thing to do and hopefully the right thing to do. When you are released from custody, you are on intensive pretrial release. You need to navigate checking in with pretrial release and getting the BART monitor on. Please use the VA folks as a resource. Please use your attorney, Mr. Campbell, as a resource. I'm going to place you in a breakout room with Mr. Campbell so you can speak to him. My question to you, Mr. Brown, is do you have any questions whatsoever regarding your return court date, your release conditions, or what has taken place in our hearing today?
Where is my court date, at here or in Battleground?
The only reason that you are there is that you are in custody. The jurisdiction for your court is the city of Battleground. You are in court in the city of Battleground.
Okay.
Do you have any other questions at all?
Yes, sir. That's all.
All righty. We are going to place Mr. Brown and Mr. Campbell back in a breakout room. And this concludes at this time, Mr. Brown's hearing.
And if the court will email me that document that the judge has just signed, I will forward that to our contact at 2Watch, so that hopefully we don't run into issues with the pay.
Once I get back from jail, I'll send it to you.
That
To sign it. Defendant signed it and then they send it back.
oh, just the hearing notice. Okay.
I'll send it to you as soon as I get it back.
Okay, thanks.
Is Hayden Wellman here?
Hey, well, I'm ready to go. Lon.
Hang tight, Mr. Wellman. I'm just need to find your paperwork. You don't happen to have the court file, do you, Ms. Gaffney?
No, Your Honor. It should be on for readiness there.
Yeah, I have a couple matters on for readiness. Madam Clerks, I don't see the Hayden I do. In my motions section. All right. Mr. Wellman, can I have you state your name and date of birth, please, for the record?
Hayden Wade Wellman, March 14th, 2004.
Mr. Wellman, you are before the court today with your attorney, Ms. Gaffney. From the paperwork that I have today, it looks like you are going to be pleading guilty to an amended charge of negligent driving in the first degree. Is that your understanding?
Yes, Your Honor.
Have you had the opportunity to speak to Ms. Gaffney about your plea today?
Yes, Your Honor.
Need any additional time to talk to her before we get started?
No, Your Honor.
If you have any questions or need to speak to her more, please get my attention during our hearing and I will allow you to continue to talk to her, okay? You are Hayden Wade Wellman. You are 19 and you've completed the 12th grade of school. Is that correct?
Yes, Your Honor.
Are you able to read and understand the English language?
Yes, Your Honor.
Okay. You're entering a plea today to an amended charge of negligent driving in the first degree. As you are giving up the right on the reckless driving charge to associated with trial, I'm going to go over the rights you're giving up and accepting the amended offer. You have the right to a speedy and public trial by an impartial jury in the county where the crimes alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you. These witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt, or you enter a plea of guilty. And you have the right to appeal a finding of guilt after trial. You understand those rights?
Yes, Your Honor.
You understand that entering your plea today, you're giving up those rights.
Yes, Your Honor.
Okay. The charge which you are pleading to is what is called a simple misdemeanor. It's subject to 90 days in jail and a $1,000 fine. I am holding up a pretrial agreement. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law?
Yes, Your Honor.
During the time you're on probation, you can be requested to pay cost, fees, and assessments as authorized by law. And if you're not a U.S. citizen, a plea can result in immigration or deportation issues. To the charge of negligent driving in the first degree, taking place on January 31st, 2023 in the city of Battleground, how do you plead?
Guilty.
Are you making this plea freely and voluntarily?
Yes, Your Honor.
No one has threatened any harm to you or made any promises to you of any kind.
No, Your Honor.
The factual basis states, in the city of Battleground, Washington on January 31st, 2023, I drove a vehicle, did not exercise ordinary care, and did some act that a reasonable, careful person would not have under the same or similar circumstances, or failed to do something that a reasonably careful person would do under the same or similar circumstances. I exhibited the effects of having consumed liquor by having the odor of liquor on my breath, or my speech, manner, appearance, behavior, lack of coordination, or otherwise exhibited that I had consumed liquor. The plea is being entered via in-ray bar. Are you in agreement with those factual statements, sir?
Yes, Your Honor.
Is this your signature on the page here?
Yes, Your Honor.
Will accept the plea, find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. What's going to happen now, Mr. Wellman, is I'm going to hear from the city attorney, Ms. Carmy. I'm then going to hear from your attorney, Ms. Gaffney. And if you choose to speak, then you also have the right to address the court before you are sentenced. Go ahead, Ms. Carmy.
Your Honor, this is actually a conflict case.
Go ahead, Mr. Busby. I wonder why Ms. Gaffney was gesturing to the screen because I didn't read the front of the file. Okay, go ahead, Mr. Busby.
Thank you, Your Honor. The city would request that the court follow the recommendation. This was a heavily negotiated case. Mr. Wellman has a prior reckless driving from 2021, a prior DWS 3 that was reduced from DWS 2 in 2021, and has had some issues with compliance with his sentence in the previous cases. That is what has resulted in the 10-day EHM recommendation and 3 days community service. And so we would ask that. I'm not sure if I had incidentally left the box checked for substance abuse evaluation. This is an in-ray bar plea. Substance abuse is not being recommended by the city, as there's no indication that alcohol was involved in this. This is a benefit of the bargain in-ray bar offer to reduce it from reckless to negligent driving in the first degree. But the city is asking for defensive driving in the second level 2, no driving without a valid license and proof of insurance, suspend the rest of the sentence for 2 years.
Ms. Gaffney?
Your Honor, we'd like to thank Mr. Busby for the opportunity for the reduction. I think it's really important. Hayden just turned 19 on March 14th of this year. So I did not want him to have a reckless driving conviction at 19 years of age. That's a second major. I do want to say that Hayden has really been an excellent person to work with. And he is always courteous with me. He's upbeat, he's positive, he listens to me, he acknowledges his actions, he's accountable. But I think what's really, really impresses me about him is he obtained a job on February 27th of this year, working at Frontier Metal Fabrication full-time, doing sandblasting work. He's working 50 hours a week. He gets overtime on Fridays when he gets time in the AM. He's doing very well. He's making $18 an hour. I think that's really good. That's a fabulous job. He's working hard. He can do the home confinement. I'm going to work with him with that. He's done home confinement before. I've met with his family. His family is very supportive of him. He realizes, like, as I told Mr. Busby, I made mistakes when I was a young driver at 19. I did. I make mistakes to this day, but I don't want that reckless to affect his ability to drive and work, because that's a productive citizen. He gets up every day, 5 days a week, and works. And I think that is really good. And I am very proud of him on that job. And I think he really, this whole thing is going to actually be a positive for him. And I'm very confident he'll do the home confinement, we'll do the community service, the 3 days, and the defensive driving level 2. We're going to ask for minimum fines as low, if the court would consider $25 payments, and he will pay the total fine. It's over $1,000, but he is working. He's going to make, I think your last paycheck was $1,400, but that was not 50 hours. That was only 40 hours. So that's a good income for a 19-year-old, and that's a good job. So we thank the prosecutor for the reduction.
Anything you want to say, Mr. Wellman?
No, Your Honor.
How old were you when you got your driver's license?
I believe I was 16.
Mm-hmm. So you've had a driver's license for 2 years?
I believe that sounds right.
Slightly over 2 years.
Yeah, something.
And in just over 2 years, you've been charged with hit and run unattended, reckless driving, driving while suspended in the second degree, and reckless driving again. I think that Ms. Gaffney's correct. I think you are a hardworking guy. I think that you are very courteous to her, which not all people are courteous to our very hardworking public defenders. But sir, you turn into an absolute knucklehead when you get behind the wheel. No other way to say it. There's people in their entire lives that don't get a criminal traffic charge. You're averaging like 2 a year right now. So this is going to go a way that has to do with what you do every time you put the key in the ignition. If you are using a vehicle in a way, the elements of reckless driving are showing willful and wanton disregard for the safety of persons or property. You can be the kindest person in the world, but if you become a menace when you get behind the wheel, you are going to end up in jail. Just a fact. Okay. There's not a judge on the planet who doesn't look at this and go, wow, this is a person who probably should not have a driver's license. In fact, if your DWS 2 doesn't get amended to a DWS 3, you're suspended for a year. But yet you have these lessons that you receive, you get these wonderful benefits, maybe because you're a nice guy, maybe because you're hardworking, but you go out and you put the key in the ignition and you go out and you do the same things again. It's baffling to me that someone would continue to walk that tightrope of accruing criminal charges just by how they get from place to place. The car is not a manifestation of your personality. It's a vehicle. It gets you from work to home. It gets you from home to the lake on a Saturday. If you continue to weaponize your driving, you will be in custody. If you come back in front of me again with another criminal charge, even if the prosecutor amends it, I don't have to follow anyone's recommendation as to sentence. And I can choose whether you have a good job or not, that it's in the community's best interest for you to not be out, for you to not be behind the wheel. And I can direct the Department of Licensing not to license you. Now I'm going to follow the recommendation today, but you had better darn well do everything that you have agreed to. I see on that pretrial agreement that if you don't comply with this home monitoring, it's jail. I won't hesitate. I won't hesitate because honestly, at some point in the future, someone will look at this and go, why was this young man never convicted of reckless driving? Why did this man never have a license suspension? Why did this young man never have high-risk insurance? You want to talk about where that $1,400 would go? It would go to your SR22. Any high-risk insurance company that sees this record, we're talking all $1,000 just to put you as a lawful driver. I'm not going to lecture you anymore. Your actions are going to be what either puts you back in front of me or gets you out of this. So it's not about words, it's about actions. All right. We'll amend the charge to negligent driving in the first degree. 90 days in jail with 77 days suspended, leaving 13 days to serve. 3 days are on community service. That equates to 24 hours community service. I'm going to see you in 3 months. Those 24 hours had better be done. You're on electronic home monitoring for 10 days. No messing around with this. Contact 2Watch, get on your home monitoring. Fine is $1,000 with 500 suspended, $500 fine to pay. Sentence is suspended for 24 months. To that fine is added a public defender recoupment of $300, a criminal traffic fee of $102.50, a conviction fee of $43, and a $150 filing fee. Costs in the amount of $1,095.50 in total. Payments can be made at $25 per month, as I want you to put your money towards your home monitoring. Okay. I want you also to be able to do your community service. Conditions of sentence: no violations of law, not to drive a motor vehicle without a valid license and proof of insurance. You are on bench probation for 24 months. You are to complete the defensive driving level 2 class through NTSI. That's an online class. You don't have to do it, take any time out of your workday. I'm going to be looking at all of these conditions. I'm making a list of them on your form. NTSI, community service, and EHM. It's a lot of abbreviations, but those are what I'm going to be looking at on the 22nd of June, 2023 at 1:30. Now, here's a little bit of salvation. If you have those completed before the 22nd of June, you may not see me again. So the circumstance is the only thing that puts you back in front of me to scrutinize this is you not getting it done. Okay. Mr. Wellman, your attorney did a wonderful job on this case for you. Do you have any questions for me regarding the sentence I have imposed today?
No, Your Honor.
Good luck, sir.
Thank you, Your Honor. Thank you, Mr. Busby.
Thank you, Ms. Gaffney. Thank you, Your Honor.
And Judge, I hate to interrupt if I am. Mr. Harris is prepared to proceed on a bench probation review.
Okay, sounds good. Let me get that ready. Mr. Harris, can I have you state your name and date of birth, please, for the record?
Joseph Harris, 11492.
Thank you, sir. You're appearing today with your attorney, Mr. Campbell. I'm just going to go over because I did review this paperwork earlier. It's like Mr. Harris was last in court on December 29th, 2022. At that time, I reassigned 20 days of work crew. Looks like after that reassignment, he completed 3 days and was terminated again. We have 17 days of work crew owing. We still do not have any mental health documentation. We've been requesting that since October. Go ahead, Mr. Campbell.
So, Your Honor, obviously, Mr. Harris is in custody. I mean, I guess he pled guilty in a felony harassment case that is in Clark County Superior Court. It's got a release date in the Clark County Jail. He thinks of next month on the 19th. So he's been engaging in mental health.
Folks, I need you outside the door because I can't hear. So step out with the attorney if you're going to have a conversation.
Did you want me to
go
start
ahead?
over? Did you want me to start over, Judge?
So I understand. I did hear that he had entered a plea to a felony charge.
Correct.
Go ahead on the rest.
And so, Mr. Harris, I think his primary concerns continue to be mental health. I think it's difficult for him in the community to engage in services largely because he is homeless. I know that he has a desire to get out of custody on his current date and probably benefits from having some contacts with the work crew. I would imagine he'll come back to the battleground community. That's where he has been for a lengthy period of time, homeless, true, but working intermittently and attempting to gain resources. So, I mean, I think what he would be doing today is admitting that he has not updated the court on his current mental health treatment, although he is engaged. in the jail, and that he has violated the provision of his sentence relating to no new law violations by pleading guilty to a harassment charge. I know from what he talked about, there's, some facts that are mitigating in relation to that conviction, but it is naturally a violation of his release conditions. And then I didn't speak to him about the work crew. Mr. Harris, did you want more time to speak to me about admitting or denying whether you have completed the work crew? The allegation is that you haven't done 17 days.
I did not complete it because I'm in here.
Yeah. So he's admitting to not completing the work crew, Judge. I guess he would probably request that Your Honor consider not converting the work crew to jail and allowing him to serve one last chance on the work crew. And if you are going to convert to jail, we'd ask for a conversion less than 1-for-1, maybe 10 days of jail as opposed to 17 days of work crew.
Thank you. I think that what's before the court at this time is that Mr. Harris entered a plea in September of 2022. He was reassigned the exact same conditions again, didn't finish his conditions, got a new felony charge, was convicted of a new felony charge. We're just not heading in a direction that is going to be something that I think that continued monitoring is going to have an impact on. Do we know on the harassment felony charge, was mental health a component of that sentence at all, Mr. Campbell?
So, Judge, it's a little bit confusing. I can see that Judge Lewis is the sentencing judge. I'm looking at the jail memorandum, and then I've looked at the guilty plea hearing. It was a joint recommendation that he engage in mental health services. But then when I look at the felony judgment and sentence, just in full disclosure, and I'm looking at it on base, so maybe I'm misreading it, but I'm going right now to provisions on mental health treatment. Looks like 4 months jail. Community custody is not marked, so he's not being supervised by DOC on this conviction. I go to the other court orders, and there are none. And I don't know if that is a mistake, because as I indicated, the plea offer is clearly that there was a meeting of the minds that he'd be directed to do those things, but it appears potentially that the current judgment and sentence does not provide for any monitoring, just in full disclosure, Your Honor. There is a provision in the felony on protections for the victim. So I should say there are some conditions on that felony, but that is, I guess, the only one I see. So I don't know why that would have been, other than potentially Judge Lewis determined that since DOC is not monitoring anything, he was not going to put conditions on the case, or it's a scrivener's error, a mistake in sentencing.
What I'm inclined to do, just thinking out loud, Ms. Carmy, is to terminate the work crew, to impose 10 days of jail to run consecutive to his existing sentence. I just don't know if we want to continue to drip out this mental health treatment that I don't know is necessarily going to be achievable based on his circumstances, and continue to have reviews on this case.
Right. And certainly that's something the city grapples with in this case too. And I also, as Mr. Campbell noted, don't see a component of mental health on the felony, but I'm not saying it's not there. I guess what I would say is I do know that likely there is some level of mental health support he's receiving in jail and will receive for the next 40 days. And with our added 10 days, I would support the court doing the conversion from work crew to jail to run consecutive.
And terminate.
And I think that given my understanding of the support in jail, I would terminate that condition of mental health.
All right. So what's going on, Mr. Harris, is we are going to be getting rid of the mental health condition. You'll continue to be on probation on these cases, to where there would be probation violations if you were to commit future new law charges. But at this time, I'm not going to set any further reviews. Your remaining 17 days of work crew is converted to 10 days jail. The 10 days jail will run consecutive to whatever felony sentence you received. And at this point, there will not be any further court proceedings in Battle Ground. Good luck, sir. Just finishing up the form, Madam Clerk, so giving you a minute.
And Judge, if I may just give the client a little bit of information while you're doing that, you're still, the conditions of your sentences relating to no contact with Michael Landry and other named victims from these cases are still in place, correct, Judge?
That is correct. Those conditions remain in place and his probation remains in place. We're just not going to continue to monitor him for mental health.
Yes, Your Honor. I just wanted to be sure that that was clear to the client on the record.
And just confirm, we're gonna put the 10 days jail on the assault 4 case.
10 days jail, yes, on the assault 4 case. Thank you.
So, Mr. Harris, you're going to serve an additional 10 days from your current release date. And then you just have to stay out of trouble and not have contact with Michael Landry and any other named victims. I'm not seeing any other victims that are named in these matters.
I got one question.
You can probably, I'll get a breakout room with you and speak to you privately about that, okay?
All right, the document that I will sign on Mr. Harris's case, I just closed so we can print that out and I'll sign it. Folks in the back, what's the name of the person here for court? Mr. Hartley. Okay.
Mr. Hartley's attorney is Angela, and they have not had a chance to connect. So they probably want to do that. She will want to do that, I'm sure.
And she's not on Zoom anymore.
I think-
She's talking to an in custody, perhaps.
I think she is with an in custody, Mr. Tellep.
And your name, sir?
Okay.
Okay. Thank you.
I'll let Ms. Angstrom know. That
Are you folks here for court? What's your name?
with Campos Graham motion.
And was Ms. Ward going to be here for that one?
I don't believe so. And I don't think it'll be necessarily opposed if you wanted to take it.
All right, Mr.
I didn't think she was appearing for the Campos Graham victims motion, though.
I just know she's gonna be here.
All right, so let's have the two folks that we're going to be providing feedback. I have a statement from Nathan Jackson and Natalie Cosette. Is that both of you? Why don't you come forward then, please? Okay. So Mr. Jackson, you submitted a statement that I have here. It looks like from back on the 27th of February. I'm just reading through it right now. What kind of changes has Mr. Campos Graham made?
He's stopped taking drugs that had been spared. He's shown he's shown initiative to become a better person, a better man. He's came a long way from what I've heard from him. He's shown progress.
And you're asking at this point that the court no longer have an order that's keeping you apart from him?
Yes, I love the guy. He's been a good father figure in my life. He's had one mess up. I forgive him. And I just would like to move on from it.
Thank you for being here. So let's hear from, this is Ms. Cosette then?
Yeah.
Okay, I'm just gonna read your statement and then might ask you a question or two, okay? What sort of changes have you seen?
Lots of changes. He's consistently working, staying away from the drugs and alcohol, going to his classes. Just trying to better himself in every way possible he can. He wants to be there for me and the boys. I dropped the restraining orders, so I've been able to see him and spend time with them. But the boys weren't ready to at the time I did, so I told them we could wait till they were ready. And they're both ready, so.
Thank you both for being here. I'm gonna have you have a seat and I want to hear from Mr. Campos Graham then, okay?
Okay,
Thank you for being here.
thanks.
All right, Mr. Campos Graham, come forward, sir. I'm just looking at the information I have from Better Way Counseling, so give me just a minute to read through that.
Okay. I've been going pretty consistently. Actually, all the way.
I want you to tell me what kind of journey you've been on over the last few months.
Few months. Been staying as busy as I can. I've been trying to learn from the class that I've been going to on how it makes me think, on how my belief system was before I started the class and how it's changing me as a man now, as a person. I mean, I still have some weeks to get done, but I think in the short period of time I've been in that class, like it's kind of made me see life in a different way, maybe my behaviors in a different way, my belief system in a different way, you know, and just hearing the stories from a lot of the other guys that are in there for the same thing, and kind of, I don't know, still learn. But I think that I'm just motivated to be a better person, a better man for myself. Because if I'm not good and I can't be a better version of me, I can't be a better version for somebody else. So I'm just really high on self-care and just staying motivated, work, keep my legs and my mind busy, my hands busy.
How old are the boys that are in this household?
Nathan's 18. Malachi's 16.
So my understanding is, are you not maybe the dad, but the father figure in this house?
I'm not their biological father, no. But I've been with their mother for 4 years, and I was in their life at some really impressionable, low teen years. So I think I've had an impact on their life, and being a better me will make it better then.
Yeah.
Better household, because I mean, what I've learned, and this is me learning, like in the last year, that like, I'd say before that, the man is the holder of the house. Like how we act is a reflection on how everybody else is going to act and feel in the house. So if I'm not good, how can anybody else be good? if I'm not doing what I'm supposed to be doing and set an example, a good example, then it pretty much sets the tone for the whole house.
Yeah.
And more than just your house.
Yeah.
Your life.
Well, and they are imprinting the behaviors that they're seeing from you.
Absolutely.
Right. So I'm a dad too. I have 2 sons.
Mhm.
So I understand that there can be the things that I say, and then there can be the actual behaviors and actions that my boys are seeing.
Right.
And the boys, as much as during their teenage years, they want you to believe that they're going to go their own direction,
Mhm.
they are absolutely going to repeat that behavior that they're seeing, good and bad.
Mhm. Definitely.
And the boys that are in your house are going to do the same thing. And the opportunity that you have after making this mistake is to show these boys that when a mistake is made, that you own the mistake,
Mhm.
that you correct the mistake, and that you can become better after it.
Absolutely.
That's going to be the journey that they see you on.
Mhm.
And it's important that they see you on that journey, right? It's important that we not hide our mistakes as adults. There is this belief that we have to have this perception that we are perfect. Not all the case. We are all works in progress.
Absolutely.
Ms. Carmi, city's position.
Yes, Your Honor, the city is not going to argue against the NCOs being terminated, I guess, with additional input. The adult victim, Ms. Collette, did ask us to drop her NCO at the time of entering the 24-month stay. So we did. At that time, the 2 minor boys were not ready to have this sort of reunion. I understand they are now. The city's not going to stand in the way of that. However, I would like to say, just on the record, the defendant's compliance has not been exceptional. The most recent DV treatment is fair, says that you show up. That's about where we're at. The defendant's been terminated from work crew and been reassigned. So I would like to say on the record that if this doesn't go the way the family wants it to go, they can re-seek protection orders through the civil process in Clark County. And I would encourage them to do so if this does not go the direction the family wishes it to go. I don't think that I have enough to object to the family's wishes at this point.
Yeah, I mean, I can see the review stuff from February. This has not been a perfect road. You are still on the road, though.
Mhm.
And you need to continue to be diligent with the things that you're doing. I will drop the no contact orders at this time.
Okay.
And we'll abide by those wishes. I will tell you folks, it does take about 24 hours to get it in the system. So there is going to be a document that you're going to get, Mr. Campos Graham, that shows that the no contact order.
Right.
Keep that in your wallet, keep that with you for a period of time, just in case, you're stopped for a tail light out, that they know in the system. But I'll sign those documents today.
Okay.
We're going to see you back here next.
May 11th.
That's a good sign that you remembered the date, because I was going to have to look for it. Yeah, May 11th at 1:30. You'll go from there. Okay?
All right.
Thank you.
Your Honor.
Good luck, sir.
Thank you.
Oh.
Yeah.
Thank you both. You need to get a copy of the paperwork. Right, are we ready on Ms. Wilson's matter,
Your Honor.
Ms. Gaffney? Okay, Ms. Wilson, come forward with your attorney. Ma'am, if I can have you state your name and date of birth, please, for the record.
Carolina Wilson, 7/30/2000.
Ms. Wilson, it looks to me from the paperwork today that you're going to be entering a plea to an amended charge of reckless driving. and that the infraction of driving without insurance is being dismissed. Is that your understanding?
Yes,
Have you had plenty of time to speak to your attorney, Ms. Gaffney, about the case today?
yes.
Do you need any additional time?
Mm,
Okay, I'm going to start going over your paperwork with you. During the time we're going over that paperwork, if you need additional time, you let me know. Is it pronounced Carolina?
Carolina, yeah.
Okay. You are Carolina Y. Wilson. You're 21. You completed the 10th grade in school. Is that correct?
Yes,
Are you able to read and understand the English language?
yes,
To the original charge of DUI, you are giving up several important rights today that I'm going to review with you. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial, and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. The right at trial to testify and have witnesses testify for you, and these witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And you have a right to appeal a finding of guilt after trial. You understand those rights?
yes,
You understand that in pleading guilty today, you're waiving or giving up those rights.
yes,
The charges you are pleading to is what is called a gross misdemeanor. It's subject to 364 days in jail and a $5,000 fine. There is a pretrial agreement that I am holding up. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by
Yes.
law? The court can have you pay cost, fees, and assessments as authorized by law during the 2-year term of probation. And if you're not a U.S. citizen, a plea can result in immigration or deportation issues. Box J has been checked that this charge does carry a mandatory 30-day license suspension. Do you understand that?
yes,
And you understand that the court cannot go below that.
yes,
To the charge of reckless driving taking place on January 15th, 2023 in the city of Battleground, Washington. How do you plead?
guilty,
Are you entering this plea freely and voluntarily?
yes,
Has anyone made any threats or promises to get you to plead guilty?
no,
The factual basis states in the city of Battleground, Washington on January 15, 2023, I drove a motor vehicle with a willful or wanton disregard for the safety of persons or property. Is that a correct statement?
yes,
I will accept the plea. Oh, one more thing. Is that your signature on the plea form?
yes,
I will accept the plea, find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. What's going to happen now, Ms. Wilson, is I'm going to hear from the city attorney, Ms. Carmy. I'm then going to hear from your attorney, Ms. Gaffney. And if you choose to speak, you also have the right to address the court. Go ahead, Ms. Carmy.
Yes, we would ask the court to follow the recommendations. It was negotiated, taking into account a lack of any prior DUI history, but also from the city's perspective, taking into account that a collision did occur. We understand that there's been minimal damage done, but we are asking for restitution to be held open for 180 days to Chloe Ricks or the owner of the Ricks family car. Otherwise, standard conditions with a reckless driving charge.
Ms. Gaffney.
Your Honor, Ms. Wilson did go out right away and she obtained the alcohol evaluation, which indicated that she did not have an alcohol problem. She attended the alcohol information school. I put that at the end of the judgment. So she's done that piece. She takes this matter very seriously. She's 21. She works at the margarita factory and she's worked there since last fall. We'd asked for $25 payments. She will do the work proof. She's going to sign up right away. We have to do a victim impact panel. And I'm very confident she's going to comply with everything she's required to do. She accepts responsibility. She realizes it's a prior for 7 years. And that should be it, Your Honor.
Don't know if we're going to get the fine fully paid within the 2 years, Ms. Gaffney.
Could you do $50 payments?
oh, yeah,
50.
I could pay it in a couple months.
You're gonna try to pay it off? Okay, so she's gonna try to get right on that fine.
All right.
And she told me she wants to get the work group behind her and get that done, so.
I want
Sounds
to get
good.
over this.
Ms. Wilson, is there anything you'd like me to know?
No,
All right, Ms. Wilson, I will follow the recommendation of the parties. It's 364 days in jail with 359 days suspended, 5 days to serve that can be served on work crew. Is Devin here today?
He's here today. I don't know if he's back.
So I don't know if our work crew chief is here quite yet, but you're able to come here and sign up for work crew. You're also going to have some information on your plea paperwork on how to get connected with work crew. Okay. Is a $5,000 fine with 4,800 suspended for a $200 fine to pay. To that is added a $150 filing fee, a DUI emergency response fee and BAC fee of $200 and $250, a $102.50 criminal traffic penalty assessment, public defender recoupment of $300 and a criminal conviction fee of $43. Total fine of $1,245.50, payments at $50 per month. Restitution to either Chloe Ricks or the Ricks family. Box has been checked. That has 6 months to be taking place. Other conditions: not to drive a vehicle without a valid license, proof of insurance, not to drive certainly after consuming any alcohol, to submit to a blood or breath test upon the reasonable request of law enforcement, no criminal violations or alcohol-related infractions, comply with any ignition interlock condition if imposed by the DOL. Sounds like you have completed your alcohol evaluation and your proof of treatment. There's also a victims panel component as well. We will see you back here to check on the work crew and the victims impact panel on the 22nd of June, 2023 at 1:30. That is a mandatory court date. If you fail to appear at that time, a warrant could be issued. If all your stuff is done, you may also have that court date excused. So stay in touch with the court, okay?
Thank you.
All right,
Your
Ms.
Honor, I
Wilson.
may have neglected to add the $30 work fee.
You did. It was there.
Okay.
Yep. All right. Thank you.
Your Honor.
All right, Ms. Engstrom, are you with us?
I am, Judge.
Okay, so I have Mr. Hartley here. Mr. Hartley, come forward, please, sir.
Your Honor, if we could handle the tele matter. I am needed in another courtroom. at the moment,
Okay,
and he's in the jail booth, I believe.
sounds good. I'm gonna have to wait just a second because our prosecutor needs to go. I apologize, Mr. Hartley. We almost got you up here. It was close. All right. So which attorney has been assigned to the Telep matter?
That's me
Ms.
as well.
Engstrom.
Also Ms. Engstrom, okay. Let me just get the court file and we'll get started on that one. Okay. Let me just get Mr. Telep's information pulled up here. Give me one moment, please. Okay. So it looks to me, well, I don't know. I didn't have this one apparently yesterday, so let me take a quick look. Right, so it looks like Ms. Engstrom that Mr. Telep was assigned 7 days of work crew. Did not complete any work crew. Also appears he was assigned. Looks like he's been assigned work crew twice and didn't do it. Also was assigned a theft awareness class. Go ahead, Ms. Engstrom.
Your Honor, the city is asking to convert the 7 days of work crew to jail and terminate probation at this time other than time pay.
Okay, Ms. Engstrom.
Your Honor, Mr. Telep, well, he had told me it was 5 days. I have not seen a file on this other than just sort of what I've been talking about with Mr. Busby and with the client who's obviously in custody. He says he didn't do the work crew because he had COVID twice, was hospitalized, was quite sick with it. I'm not opposed to an admission to the PV and a conversion to jail in some capacity, simply to get this sort of behind him and over with. He is trying to get out and start a new job that he just got. He does have local ties to the community, so I do think he's around and is not going anywhere, but that's where we're at on this.
Okay, Mr. Telep, is there anything you'd like me to know?
No, sir. Other than I really should have got it done or contacted you guys after I got better from the COVID, which I failed to do, which I'm sorry.
Okay. I am going to follow the recommendation of the city. I will convert the 7 days of work crew to 7 days of jail. I am not going to be asking for the theft class. After the 7 days of jail have been completed, we will terminate probation on Mr. Tellef's matter.
Um,
Can he get credit for time served, Your Honor? I believe he's been in there
If he's not being held in any other matters, how long has he been in for?
2 days.
So he certainly would get credit for any time he's been held on this case, and that would leave 5 days remaining.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Your Honor.
All right, so I just am closing out on the probation form, Madam Clerk. So if you want to print that out for me, I'm happy to sign that. Let's try again with Mr. Hart. See if we can get him up there. And Ms. Ingstrom. Okay. All right, Mr. Hartley, can I have you state your name and date of birth, please, for the record?
Michael Hartley, 11/02/1989.
Okay. So it looks like, Mr. Hartley, what's going on? The court had reached out to you. It looks like we need perhaps a new address for you. There's an address, it looks like in Port Angeles, that documents were sent to that have been returned.
Oh, yes, we updated it downstairs, or when we're signing in, right up here.
Oh, just now you
Yeah.
updated it? Okay, well, that's good. That'll be in the system then. My understanding is that your attorney, Ms. Ingstrom, is joining us on Zoom. I think she had been unable to reach you. Is there, I'm trying to see at what perhaps was the contact information. This was not a case that I was here for. It looks like Ms. Hawk was here. So let's do this. Is there a phone number Ms. Ingstrom could perhaps write down that she could reach you at if she needs to contact you?
Yes, yeah.
360, Ms. Ingstrom?
I've got it, yep.
605
605
5110.
5110.
Okay. And do we have an updated address as well? I have one in Port Angeles.
We have an address that he has provided to the court. Is it showing up in the system, Madam Clerks?
No, it's up with the bailiffs. We won't be able to update it
Okay.
until tomorrow.
So can you tell me the new address and I'll also give that to the public defender?
Let me give the PO box or the maybe already.
No, it can be the PO box.
Okay, so PO box 313.
Hmm.
Ridgefield, Washington. 98642.
Thank you.
Okay. So my thought at this time with the two pending charges, and these are fairly recent cases, is to set this over a week or two to allow Mr. Hartley to be able to talk to his attorney. We're not going to be able to move this forward without that. Now that Ms. Ingstrom has your contact information, my thought would be to set this matter out. Ms. Ingstrom, are you here 2 weeks from now?
Let me double check. Yes, on the 13th.
So Mr. Hartley, could you come back here on the 13th to allow the next 2 weeks for you to be able to speak to your attorney?
Yes, Your Honor.
Okay. I'm just going to do a return to court form, Mr. Hartley. And do you have a business card for Ms. Ingstrom?
A business card?
Yeah.
No.
Do we have, we don't have cards from Ms. Ingstrom? Okay. So I will have Ms. Ingstrom will reach out to you. And she has your new phone number or the phone number.
It's recently new. I think I
Recent
gave it
phone
wrong.
number.
Yeah,
That's
last time I
okay.
talked
That's
to her.
okay. Conditions of release.
Sorry, I was wondering if that phone number accepts text messages. Can I text you my phone number?
Yes,
Okay.
Okay, release conditions remain in place. If you have any other questions, Mr. Hartley, we're going to get you some documents over by the door. Once you have it, you are free to go. Thank you for your patience this morning.
thank you, Your Honor.
Thank you. And Ms. Engstrom, are you ready on Ms. Tatum?
Yes, Your Honor.
Ms. Tatum, could I have you unmute and turn your camera on, please?
Hello?
Thank you very much. Ms. Tatum, can I have you state your name and date of birth, please, for the record?
Dreama Tatum, 5/26/84.
So what I'm going to do, Ms. Tatum, because we're having a little issue with your connection, is to turn your camera back off now that I have identified you. Sometimes that helps our connection, okay? Ms. Tatum, if you want to turn your camera off, that would allow us to probably have a better audio connection with you for the plea. Okay. Can you still hear me, Ms. Tatum?
In Your Honor.
Yes.
All right, no problem, Ms. Engstrom. Take your moment, get a drink.
Sorry, I've been sick all week.
No problem.
Your Honor, this, I thought was going to be a plea last night. She wasn't able to come in today. Her PO wasn't in this morning to get permission to come out of Cowlitz County. I had told her to appear on phone or Zoom if she wasn't able to come in person. And we would likely just set it over to give us a chance to talk a little bit further to the DA and finalize some details on that.
Okay, so we're not going to be resolving the case today. We're going to be setting over.
Correct.
Do you want to set Ms. Tatum also to that April 13th docket?
That would be fine.
Okay. Ms. Tatum, would you prefer to come back to court here in person on the 13th of April or the 27th of April? It's your choice. Ms. Tatum?
The 13th would be fine.
Okay, we'll have you back here on the 13th of April. Do you want us to still send you mail to general delivery? Okay. All right, Ms. Tatum, we will see you on April 13th at 10 a.m. Please make sure you're staying in touch with Ms. Engstrom, okay?
Yes.
Thank you, Ms. Tatum. You can log out. Have a good day.
Thank you. Goodbye.
And Ms. Engstrom, is that your last matter?
I believe it is, Your Honor.
I hope you feel better. Good luck.
Thank you.
All right, take care. Okay. Do we have more folks for jail booths still coming up? Apparently cannot count to 7, but
We have, Ms. Ford in the room with Isaiah, we have been thinking more.
Okay, Ms. Gavin.
We're on, that Mr. Kano's 6, and then Ms. Mollet will be 7, but she's not down yet.
Yeah. Jill, too.
Okay. That was always the prevailing law school joke, is that we all went to law school not to avoid math.
And
But-
science.
But I can calculate 30% or something. But- We
You
all
and
know
my
why.
husband, you and my husband.
Sorry, you're not going to take a phone call. Really. Okay.
Oh. Okay. Well, it sounds like we have Ms. Ward in a jail booth. We have Ms. Bolette that is not down yet. I have called, I guess I have one more motion hearing for Kaylee Atkinson.
Correct. Mr. Cheney is going to appear with that.
Okay. Any idea when he'll be joining us?
I believe 11 o'clock.
Okay.
I mean,
I'll read the statement of the victim, I suppose. Clerks, have you been able to take a break? Okay, just want to make sure. Well, I think I might. As soon as I know, as soon as I step down, the jail booth will be ready. All right, and it's 10:44. Yeah, why don't we stand in recess for 15 minutes till 11 a.m.
Okay.
And we should have Mr. Cheney in at least one jail booth at that time, and we'll go from there. All right, court will be in recess till 11 a.m.
Come on, Mary Kay, pick it up. Pick it up. It not working
We had to restart everything because it disconnected us.
to the jail?
Yeah.
Wow, so you gotta wait and then we'll go into the,
Yeah,
What?
so she's gonna, we have to put the password, all that in there again.
I'm sorry.
We have problems with those jail dues all the time.
You guys are way ahead of it though. I mean, before COVID, I mean, when COVID hit, everybody was trying.
We're still trying to connect the jail, it disconnected both of them. Oh, here. They're gonna have it, and then I think what. Okay. Yep.
Thank you.
That is a data. That's the study for the agent.
Mary Kay, can you let Rebecca know we're ready? Whenever Rebecca,
Oh,
can you let her
yeah,
know we're
okay,
ready?
well, sure.
Yeah, thank you.
We just had to reconnect the jail, so Kay is working on getting them into breakout rooms. There she is, she did now. She'd asked me to put her in a breakout room, but it was. Yeah, if you do it, the jail will be muted, so we have to let them post two breakout rooms for the jail. Got it. And if they're cheating out in our.
Mr. Kano, can I have you state your name and date of birth, please, for the record?
Isaiah Keith Cano,
Your date of birth as well, please.
6/1993.
Thank you. Mr. Kano, your attorney, Ms. Ward, is present with us here in the courtroom. Go ahead, Ms. Ward.
Yes, Your Honor, I've handed forward a statement on plea of guilty to an amended charge on count 2 of driving while suspended in the 2nd degree. Count 1, operating motor vehicle without ignition interlock device. I've gone over that statement on plea of guilty with Mr. Kano, and it's our desire to enter that at this time.
Mr. Kano, did you have plenty of time to talk to your attorney, Ms. Ward?
Yes, sir.
Do you need any additional time to speak to her at all?
No.
If during our plea today you need some additional time, please get my attention and I will allow you to speak to her again, okay?
Yes, sir.
You are Isaiah Keith Kano, you're 29 and you have your GED, is that correct?
Yes, sir.
Are you able to read and understand the English language?
Yes, sir.
You're entering pleas today to 2 charges, operating a vehicle without an interlock device and driving while suspended in the 2nd degree. Is that your understanding?
Yes, sir.
All right. In entering your plea today, you're giving up several important rights on both charges. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial, and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and these witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. Do you understand those rights?
Yes, sir.
And do you understand in entering your plea today, you're giving up those rights?
Yes, sir.
Both charges you are pleading to are what are called gross misdemeanors. They are subject to 364 days in jail and a $5,000 fine. There is a pretrial agreement that I'm holding up. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law?
Yes, sir.
The court can place you on probation on each of these charges for a time frame of 2 years and have you pay cost, fees, and assessments as authorized by law. And if you're not a U.S. citizen, a plea can result in immigration or deportation issues. Box J on your plea form has been checked that this driving while suspended 2nd degree has a minimum punishment of 1 year license suspension. Do you understand the court cannot go below that number?
Yes, sir.
To the charge of operating a motor vehicle without an interlock device taking place on August 29th, 2022 in the city of Battle Ground, Washington, how do you plead?
Guilty.
To the charge of driving while suspended in the 2nd degree taking place on the same date, also in the city of Battle Ground, Washington, how do you plead?
Guilty.
To both charges, are you entering your pleas freely and voluntarily?
Yes, sir.
Has anyone made any threats or promises to you to get you to plead guilty?
No, sir.
Factual basis states on or about August 29th, 2022 in the city of Battle Ground, state of Washington, I drove a motor vehicle while my license was revoked or suspended in the 2nd degree and without an ignition interlock device, despite knowing such device was required on the vehicle I was operating. Are those correct statements?
Yes, sir.
I will accept the pleas, find them knowing, intelligently, and voluntarily made after advice of rights and advice of counsel. What's going to happen now, Mr. Kano, is I'm going to hear from the city attorney, Ms. Carmi. I'm then going to hear from your attorney, Ms. Ward. And if you choose to speak, you also have the right to address the court. Go ahead, Ms. Carmi.
Yes, Your Honor, in this case, this was a negotiated matter. Does take into account Mr. Kano's failures to appear with this court as well. He has pending charges such that we would expect that it is unlikely he'll have completed the substance abuse evaluation and treatment by his next court date. We anticipate there will be jail time on his other cases. Certainly, I just want to note that for the record, so that at his first review, that is something we probably expect. But during the pendency of his case, we are asking for that to be a condition of his case, although it may not be done within the 60-day timeframe on the JNS. Otherwise, we would ask Your Honor to follow the recommendation.
Ms. Ward.
Your Honor, we would ask Your Honor to follow the recommendation. We think it's fair and appropriate under the circumstances and the result of heavy negotiations. I do take note that I agree that with counsel that he will likely not have that substance abuse evaluation and be actively in treatment by his next review date, as he is looking at potentially some substantial felony time. I will note that his charges there are possession of a controlled substance, so it may be that he may be required to do that as part of the felony. We may want to look at that down the road because requiring it twice is not probably something that will be doable for him or fruitful. So we may just simply want to track along with what those requirements look like. But for that, we would submit that he has 7 days credit for time served at this point. Although he has been held on the felony at this point as well, but he has been in custody since the 24th. We would ask Your Honor not to impose any of the additional non-mandatory financial obligations. He hasn't been employed since COVID. When he's not in custody, he lives with his girlfriend who covers most of the expenses. He does receive government assistance in the form of food stamps. He has substantial in the thousands fines and fees and collections already. And with additional felony time, he does not look to have the prospect to have any means in which to pay any additional financial obligations at this time. Thank you, Your Honor.
Mr. Cano, is there anything you'd like the court to know?
I'm probably gonna be going to prison for like a year and a day at least, so I'm just letting you guys know, so.
All right. I will follow the recommendation of the parties. Count 1, operating a motor vehicle without an interlock device, 364 days in jail with 354 days suspended, 10 days to serve in custody, $5,000 fine, all 5,000 suspended pursuant Blazina. Count 2, driving while suspended in the second degree, 364 days in jail with 354 days suspended, 10 days to serve. Those sanctions are to run consecutive to one another for a total of 20 days in jail. We will note credit time served for 7 days, leaving a remaining balance of 13 days in jail. Again, on count 2, 5,000 with all 5,000 suspended under Blazina. I'm not going to assign an alcohol drug evaluation. I mean, if he's going to prison and these aren't specific charges that have a substance abuse component to it. Hang tight. I'm ruling at this point.
Understood, Your Honor.
Okay. So I'm going to waive the alcohol drug evaluation condition. I'm also going to waive the return date at this time. I don't think there's anything meaningful for the court to look at that time. Mr. Cano, you'll be on probation on these cases for 2 years. If you were to get new criminal charges, we can certainly bring you back for probation violations. This does conclude your cases in Battleground. I wish you good luck with your stuff in the future. Thank you, sir.
Thank you.
All right, Ms. Gaffney, are we ready on Ms. Mullet?
Yes, Your Honor,
Oh.
just getting the paperwork.
In my stack of.
There we go. Thank you. Not doing it. So we just, but we didn't fill out the sanction section.
Yeah.
Those are Ridgefield files, you missing all that?
Ms. Mullet, if I could have you state your name and date of birth, please, for the record.
Mackenzie and Mullet, 119-2000.
Ms. Mullet, your attorney, Ms. Gaffney, is present with us here in the courtroom. Have you had plenty of time to talk to Ms. Gaffney this morning?
Yeah,
You need any additional time?
no.
All right, go ahead, Ms. Gaffney.
Your Honor, we're here, we owe 5 days work through on a reckless driving, ending in number 656. And we owe 5 days work crew on the theft charge. Ending in 2013. There's also a theft awareness class on the theft charge and a defensive driving on the reckless case. And we are admitting that the work crew has not been done. And the prosecutor and I have a stipulated sentence of 3 days jail. She has been in jail now for about a week. And I believe I'm free to argue against reassignment on the theft class and the defensive driving. And I would argue that we won't need that because she has a pending felony taking a motor vehicle. Mr. Terry's representing her on that matter, and I anticipate she'd have supervision on that case. Thank you, Your Honor.
Ms. Carmen.
Yes, Your Honor, we are in agreement to convert the work crew. I think we've been at this case for quite a while now, convert it to jail time. The city is asking, and certainly it will be up to Your Honor, but the city is asking for the theft awareness and the driving course to be reassigned. We do think that's important in this case. We understand that involves further review with Ms. Millay, but frankly, when she was before this court before, the only exception to quote unquote letting her off the hook for those things was if she was in inpatient treatment. She's told us before that was going to happen. It didn't happen. So we do think there needs to be a level of accountability still for Ms. Millay.
Ms. Mullen, is there anything you'd like the court to know, ma'am?
I mean, no, not really. Just like, I didn't hold myself accountable or anything like that. And honestly, I should have been. There's nothing more to it than that. But when I post my bail for my felony cases or whatever and get out of here, my mom and I have talked about me going to ABHS or whatever up in Spokane, maybe, because I don't think I can do it here in Vancouver. But it's all here, like, again, it's all hearsay to the court until they see it happens and I hold myself accountable. But I mean, I've been in jail for a week and I've been clean, so.
Right.
I'm just ready, like, to take any like whatever punishment I need to take for not doing the work crew because I didn't make it like a priority. So.
All right, so here's what we're gonna do. I'm not gonna follow the recommendation of the parties. Ms. Millett's been in front of this court a number of times. She's made a number of promises. She's never done anything she said she was going to do across the board. It's complete fabrications with her, from telling us she was going to treatment, telling us that she was gonna, it's just not happening for her. And she continues every time she gets out to use. So my only power is to keep her in custody longer. I'm going to take all 10 days of work crew that she didn't do any of, and I'm going to convert it straight to jail. Ms. Millett will serve 10 days jail on this matter. I am not going to impose a defensive driving condition. I don't think her issue is driving. Her issue is drug abuse. I am not going to impose a theft class. Her issue is drug abuse. The only thing that stops her from using is being in custody. The only time I've ever seen her sober is when she's in jail. So at this time, certainly if she works something out with her mom and bails out and goes into treatment, I wish her all of the best. But anytime she gets out, she just doesn't do what she says she's going to do. So 10 days jail. Probation on the cases will remain. We are not going to set any future return dates on this case. Certainly we'll continue to monitor. If Ms. Millett continues to commit crimes, she will be back on these matters. But if not, we're not going to set continued reviews for her not to do things. So that resolves that matter.
Thank you, Your Honor.
Your Honor, is she supposed to receive any credit for time served? She's been there since the 24th.
If she's held on our matters, she would get credit for time served. She has not been held on our matters. The answer would be no. So I think she has been held on these cases, so she would get credit time served.
I'm showing bail on the case ending in 2013.
I mean, I can't constitutionally not give her credit on cases she's been held on, so I'm more than happy to do that. I appreciate the question, Ms. Landwehr. All right, so Mr. Cheney is with us. Mr. Cheney.
Yes, Your Honor. Good afternoon or good morning.
Good afternoon. Well, good afternoon, morning. We're still in morning. Okay, so Mr. Cheney's here. I have Ms. Atkinson in the courtroom. I also have Mr. Puglisi. Puglisi. I did read Mr. Puglisi's statement that he had submitted back on the 2nd of March. Mr. Puglisi, as the protected party, is there anything else you would like me to know that was not included in your statement? Why don't you come up here if you want to speak, because you need to be on the record.
And Your Honor, also, Mr. Cheney did send to me a stay that he was hoping to enter on this particular case today, if I can approach. And
Well, that's going to probably be more. So is it going to be rescinding the NCO?
so the agreement is that there is no further NCO, and the city is in agreement to have it rescinded based on my contact with the parties.
Okay. So while I appreciate you being here today, my understanding is that a separate proceeding is going to be happening with Ms. Atkinson that also will get rid of the no contact order. So again, we're not attempting to have you here just to spin your tires or anything like that. But it sounds like there's been a disposition reached in the case that's going to be dispositive. You are welcome to stay. But what I'm going to do is have you have a seat and have Ms. Atkinson come up here, because we're going to have to do her stay, and that will be dispositive. It sounds like on the no contact order. Okay.
Yes, sir.
All right. Thank
And
you.
I believe that is accurate.
Okay. All right. So Ms. Atkinson, if you could come forward, ma'am. And for the record, could I have you state your name and date of birth, please, for the record?
Yes, Kaylee Atkinson, and my date of birth is 4/11/2000.
Okay. Ms. Atkinson, I have a document that has been handed to me for a stay of proceedings. You have your attorney, Mr. Cheney, who is present with us over Zoom. Have you had plenty of time to review with your attorney this stay agreement?
Yes, Your Honor.
Do you need any additional time?
No.
What I tell everybody about these stays is I'm not a party to them. This is a contract between yourself and the city of Battleground. My job is to be the referee. It's to make sure that you understand the things that you are obligated to do. And then at the tail end, make sure that the city follows through with their obligations, which is generally dismissal of the charge. Okay. So with that, I'm going to review with you the stay agreement to make sure that you have a good understanding of what you are looking at. There are some fees and costs associated with the stay. There is a filing fee recoupment of $150, supervision fee of $150, so a total financial obligation of $300. Mr. Cheney, you are a public defender on the case. Why is the public defender recoupment not being requested?
No, Your Honor, this is a private retained case.
Oh, I apologize then. Disregard that. You are to remain compliant with any payment plans in regards to those $300. You are to complete 24 hours of community service. The court will give you a form where you will list the provider where you are doing the community service. There generally will be a person then that signs off on it, and we are able to contact to verify that the community service is done. I'm going to set a review in 3 months. I think you could get that completed within the 3-month time frame. Okay.
Your Honor, could I add one note just so the court is aware? Ms.
Sure.
Atkinson being pregnant, certainly she's not opposed to doing the community service, but if there were to be some kind of pregnancy complications or something, we may come back to the court and ask for an extension on that time to get the 24 hours completed. Again, just depending on how the pregnancy plays out.
So my limited recollection of my wife's own pregnancies, I think earlier in the process generally is easier than later in the process. And certainly once the baby arrives, community service is probably not going to be on the table. So we're certainly not asking you to do anything that you're not medically able to do. Do not take any unnecessary risks. That said, I think earlier rather than later makes more sense. But again, I'm certainly not a doctor or an obstetrician or anything of that nature. You are to complete an alcohol evaluation and comply with strike that. An anger evaluation and comply with recommended treatment. You're not to have any new criminal charges. You're to provide that anger evaluator with a copy of your police reports for the evaluation. You're to appear at all future court dates. In entering the stay today to the original charge of assault 4DV, which is a gross misdemeanor subject to 364 days in jail and a $5,000 fine, you are giving up some very important rights. The first of which is you're waiving your right to have a trial by jury. You understand that, right?
Yes.
And are these your, it looks like maybe electronic initials next to this?
Yes, sir.
You have any questions about that right to a jury trial? Okay. You also have the right to a speedy trial. I see the same initials. Do you understand what your right to a speedy trial means?
Yes, Your Honor.
You're doing a waiver commencing or beginning today's date 1 year from now. Do you understand that in doing that waiver, it would give 90 additional days to the city of Battleground from that date forward if it became necessary to take your stay away? Do you understand that?
Yes.
Okay. And are you in agreement with that?
Yes.
Okay. Looks like you have electronically signed the stay agreement. Do you have any questions for your attorney, Mr. Cheney, or for myself before I sign you into this agreement?
No, Your Honor.
We'll sign you on to the stay agreement. We are going to set a review date on the 22nd of June, 2023. This is going to review the anger evaluation and treatment. It is also going to review the community service. We're going to set a final review date to take place a year from now. That's going to be on the 28th of March, 2024 at 1:30 p.m. Okay. If you have any questions at all, Ms. Atkinson, regarding the stay agreement?
No, Your Honor.
My assumption, Ms. Carmi, is that I'm looking for another form where I'm going to now revoke the NCO.
Do you have the forms to terminate NCO in there? You do have one up there. I'll come
I
over
will
there.
sign off on that as I have it. We're going to get you some paperwork over by the door. Please keep the document we give you.
Oh, I've got one.
It takes about 24 hours for the law enforcement services to update that. So put it in your purse, whatever else, just in case you two are stopped with a taillight out or something like that. We don't have an issue with someone getting arrested, okay?
Okay. Thank you.
Leave some paperwork by the door. Once you have it, you're free to go. Good luck. Thank you. Thank you, Mr. Cheney.
Thank you, Your Honor.
Thank you. Did you want to be heard on any of the warrants from this morning? I have 3, all driving while suspended, it looks like.
Okay. Oh, and one of them I was going to reduce. No, Your Honor, we would leave
The
it to
one that
court.
was going to be reduced, I'm just going to sign off on that, so we don't have to worry about that one.
Okay.
And so at this time, I'm going to call the 2 remaining matters from our morning arraignment docket. The first is Ron Heasley, 3A00164-236. This is a This is an incident from a while ago. I may have misspoke. This is a failure to transfer title. From January 27th, 2023. I did find probable cause for that charge. We'll note that Mr. Heasley, it looks like some steps to cancel his warrant, perhaps, to get back on the docket, but has not appeared today. It is now 3 hours after the time for arraignment. Warrant to issue in the case in the standard amount. The final matter we have is Dan Wilcox. This is 3A0254-384. Mr. Wilcox is a driving while suspended third degree from March 19th, 2023. Reviewing his citation, he has the appearance date of March 30th, 2023 at 8:30 in the morning. Again, I did review this and I did find probable cause. It's 3 hours after this time, Mr. Wilcox has not appeared. Warrant has been authorized in the standard amount. All right. So I'm going to give the clerks the choice. Do we want me to do some phone called mitigation hearings, or do we want to be done for the morning? Go off the record. Don't everybody talk at once. All right, well, let me see if I can knock out a couple mitigations. Do we have one interpreter matter this afternoon, or 3?
Let's see.
Looks like I have a file for a Mr. Sanchez Escamilla.
We have a contested.
I think that's a interpreter and it's contested.
Oh, okay, it's a contested infraction hearing for 3.
Yeah.
Okay. All right, let's see if we can knock out about 15 minutes of mitigations and then remind me, because it's been a minute since I've done this. Do I dial 1 or not? No 1.
But dial fast.
That was remembered, huh? Not the swiftest of dialers. Let me figure out. I love the ones that we don't have any phone number for. The first one, Mr. Aday, I don't see any phone number at all on his case. Am I wrong about that? There's not one on the citation that I'm seeing. Okay, well, let's strike 1. Let's see, Ms. Dallum.
Your call has been forwarded to
Your call has been.
All right, I know what I'm beat. Let's recess for lunch, go off the record. No dialing issues at least, huh?